This is a guide to understanding appeals and how to file an appeal in the state of Georgia. I'm going to cover the process of filing an appeal. You can appeal a judgment that was obtained via pleadings, or a judgment that was obtained at trial. Typically you'll be appealing judgments from the state court or the superior court. And then we just want to ensure that all your rights are protected. Let's face it, lawsuits involve matters that are highly disputed. Otherwise, both parties wouldn't even be there in the first place. So there are a lot of situations where people believe that whatever transpired in that lawsuit might not have been the best ruling, and they just want another chance to bring their case in front of a judge or jury again. So our law firm, we've been handling civil cases at the trial level for decades. We've processed a large number of appeals, and we'd be happy to provide a free consultation if you find yourself in this position. Just remember that in this circumstance, that time is definitely of the essence, and I'll explain some of the deadlines that you'll be dealing with as I go on here. So one of the first things to understand is that an appeal is not actually it's not an actual retrial or a new trial in and of itself, where you would bring your witnesses and introduce all your evidence again like you did at that lower court level. Instead, an appeal is a request for a higher court to basically review the decision made by a lower court to determine if there were any legal errors that could have affected the outcome. That's what you're looking for, legal errors that occurred on the lower court level. So when considering an appeal and your likelihood of success, then you need to make an honest legal assessment of everything involved in that trial court ruling, rather than just the fact that you are unhappy about whether you won or lost at that level. So to begin the appeal process in Georgia, the first step is you need to file a notice of appeal. Okay, now that's filed in it's filed with the clerk of court in the court that issued that original judgment, that lower court. And this document essentially just informs the court and the opposing parties that you're intending to file an appeal. And if you also think of this, as the legal process involves a lot of strategy from both sides, you often see this notice as a tactic. Maybe one side doesn't even intend to go through with the appeal at all, but thinks by filing the notice, it might improve their chances for some type of settlement in the case. In any event, the most important thing that you need to be aware of is that that notice of appeal has to be filed within 30 days of your judgment that you're appealing. So this is a hard and fast deadline, and missing it can result in your appeal being dismissed. All right, next, after filing that notice of appeal, you're going to need to prepare an appellate brief. And this is a written document that basically just outlines your arguments and then the legal basis for your appeal. So it's essential to just articulate all of these errors that I talked about, any errors that you thought were made by the trial court. And there's a wide range of areas to focus on here, and these could include things like the application of the law. It can include a large number of procedural issues, or maybe it would be an error, say in the admission of some kind of evidence that happened at that trial. Maybe you wanted to bring in a piece of evidence. Maybe it was some type of admission made by somebody, and you felt that admission was just one of the real strengths of your case. But the judge ruled in favor of the other party, and maybe saying that admission was considered hearsay or something like that, and they didn't allow it in. Well, that might be an error that you would focus on there. So all these areas you would just need to include in your appellate brief and then you're going to give all the case citations that support your argument. So in addition to the appellate brief, you'll also need to order the entire trial record. And that's going to be all the transcripts, relevant documents, all the exhibits that were admitted into evidence, so that all of that can then be transmitted to the appellate court along with your filing. So the record of your case is crucial because the appellate court's review is going to be based solely on what is contained in that trial court record. And no matter what kind of evidence you might have thought you should have brought in at that lower court trial, you're just not going to be able to introduce any new evidence on appeal. So the appellate court's only going to review what actually came in the lower court. Okay, so once the appellate brief is filed and the record is transmitted, the opposing party then is going to have an opportunity to respond with their own brief. And from that point, it's in the hands of the appellate court. A lot of things can happen there. They could either rule on the briefs, they might schedule oral arguments from the lawyers. So at that point, here's a list really of some of the various outcomes that typically happen. First, you could see an affirmation of the lower court decision. And that's where the appellate court basically agrees with the decision of the lower court and just upholds the original judgment. And that means that the appellate court didn't find any significant errors that affected the outcome of the case. You could see a reversal of the lower court's decision. That's where the appellate court disagrees with the lower court's decision, and they actually overturn that. So if that's reversed, the appellate court could either then just render a decision by itself, or it could remand the case back down to the lower court for a ruling. Another option is that the appellate court could remand for a new trial or further proceedings. That's where they just send it back to the lower court for some other type of action. That really often occurs if they find that there were errors that needed to be corrected, or maybe additional proceedings are necessary to resolve certain issues. The lower court may need to conduct a whole new trial or take specific actions that were directed by the appellate court. And then occasionally you could see what's called a modification of the judgment. That's where the appellate court would just modify the lower court's ruling without actually overturning the entire judgment. So this can involve changing certain aspects of the judgment. Maybe it changes certain amounts of damages that were awarded. And then lastly, you often see a dismissal of the appeal. That's a very common occurrence. That's where the appellate court just fully dismisses the appeal in its entirety, maybe for procedural reasons. For example, if the appeal wasn't filed correctly, or it certainly wasn't filed timely, as I mentioned earlier, or maybe they just felt that it just lacked standing, or they could have just felt that it was just frivolous altogether. And it was no merit to even filing it in the first place. So in summary, each of these outcomes just really depends on the specific circumstances of the case itself, because every single case that is brought in court is going to be unique in its own way, one way or the other. So just give us a call if you find that you're in a situation where you believe an appeal might be necessary.